Sir, you need to leave. We've got complaints about you loitering and making people uncomfortable.
Loitering? I'm literally just reading. I haven't said a word to anyone.
Look, this isn't a shelter. You're disturbing the peace, so pack it up.
This is a public library. I'm sitting here quietly with my law books and my laptop.
I don't care what you're doing. Leave right now or you're getting arrested.
Go ahead, arrest me.
The library security camera captured everything. Every word, every violation. Officer Bradley Carr had no idea the man he was about to handcuff wasn't just any library patron. He was Elias Thorne, a civil rights attorney with 18 years of experience, a former federal prosecutor, and a lawyer who had successfully sued 3 police departments for racial profiling. What happened next would cost Carr his career, cost the city $3.8 million, and trigger a Department of Justice investigation that would expose systemic racism in the Chicago Police Department. Drop a comment right now. Where are you watching from? If you believe you can be arrested for reading while Black hit that subscribe button, this story gets even more shocking. The Harold Washington Library sits on State Street in downtown Chicago. Glass and steel architecture, massive reading rooms with floor-to-ceiling windows overlooking the city. It's not just a library, it's a community space where students, study professionals work remotely, homeless individuals find shelter, and citizens access information. The 9th floor reading room is the quietest. Rows of study tables, individual carrels with desk lamps, computer terminals along the walls, signs everywhere, silence please. This is where Elias Thorne chose to work that Tuesday afternoon in March. Elias Thorne was 43 years old. Harvard Law School topped 10% of his class. 5 years as an assistant U.S. attorney, prosecuting civil rights violations and federal crimes. 13 years in private practice specializing in police misconduct, employment discrimination, and constitutional law. He'd won landmark cases, $4.2 million settlement against Detroit PD for wrongful arrest, $5.7 million against Milwaukee PD for excessive force, $2.9 million against Indianapolis PD for racial profiling. He'd argued before the 7th Circuit Court of Appeals. He'd been quoted in the New York Times, Washington Post, and on NPR about police reform. He taught constitutional law as an adjunct professor at Northwestern University Pritzker School of Law. Bar associations invited him to speak. Civil rights organizations consulted him on policy. At 43, Elias Thorne was exactly what he'd worked to become, one of the Midwest's most respected civil rights attorneys. That Tuesday afternoon, Elias had a deposition scheduled for the next morning. Police excessive force case. He needed to review case law, prepare questions, organize exhibits. His office was being renovated. Workers everywhere. Construction noise making concentration impossible. So he went to the library at 2:15 p.m. He found a table in the reading room near the windows, natural light quiet. He unpacked his laptop, his legal pad, 3 case law books he'd checked out from the law library, and a coffee he'd bought downstairs. He wore khakis, a button-down shirt, and a blazer. Professional but casual. He looked like what he was, a lawyer working at a library. For 30 minutes, he read peacefully. He took notes on his legal pad. He highlighted passages in the case law books. He typed on his laptop. He sipped his coffee. He bothered no one. He spoke to no one. He was completely absorbed in his work. But to one person in that library, Elias Thorne's presence was a problem, and that person decided to do something about it. Patricia Vance was 52 years old. She'd been a reference librarian at the Harold Washington Library for 14 years. She considered herself a guardian of library standards. She believed libraries should be quiet, orderly, respectable places. And lately, she'd become increasingly frustrated with what she called undesirable people using the library. Homeless individuals sleeping at tables, teenagers being loud people who in her mind didn't belong. That afternoon, Patricia noticed Elias, a black man sitting alone at a table with books and a laptop. She watched him for 10 minutes. Something about him made her uncomfortable. She couldn't articulate what. He wasn't being loud. He wasn't bothering anyone, but he just didn't look right to her. He looked like he was casing the place, maybe planning to steal laptops, maybe dealing drugs. Her assumptions were entirely based on race, though she would never admit that to herself. Have you ever been profiled in a library or bookstore? Type yes or no in the comments. Patricia approached the circulation desk where her colleague was working. There's a guy on the 9th floor who's been there a while. I think he's loitering. Her colleague looked up. Is he causing problems? Not exactly, but he doesn't look like he's really here to read. He looks suspicious. Her colleague shrugged. If he's not causing problems, probably just leave him alone. Patricia wasn't satisfied. She went to her supervisor. There's a suspicious individual on the ninth floor. I think we should call security. The supervisor asked the same questions. Is he being disruptive, threatening anyone violating library policy? Patricia couldn't point to any specific violation, but she insisted something felt wrong. The supervisor, wanting to avoid conflict with a longtime employee, agreed to call building security. Building security arrived 10 minutes later. Officer David Wu had worked library security for 6 years. He was calm professional trained in de-escalation. He asked Patricia to show him the suspicious person. They walked to the reading room. Patricia pointed at Elias, still sitting quietly reading his case law book, taking notes. That's him. He's been here over 30 minutes. Officer Wu observed for a moment. He's just reading. What's the problem? He doesn't look like he belongs here. Wu, who was Asian American and had experienced his own share of profiling, immediately understood what was happening. Ma'am, this is a public library. Everyone belongs here. I'm not going to bother someone who's reading quietly. Patricia's face flushed. Fine, I'll call the police. Wu tried to stop her. That's not necessary. He's not breaking any laws. Patricia walked away and called 911. Chicago Police Dispatch received the call at 3:02 p.m. There's a suspicious individual at Harold Washington Library, 9th floor. Caller reports he's been loitering for an extended period and making patrons uncomfortable. What's he doing that's suspicious? Just sitting there. He looks out of place. Is he threatening anyone being disruptive? Not according to the caller, but she insists something's wrong. A unit was dispatched. Officer Bradley Carr responded. Officer Bradley Carr was 36 years old, 9 years with Chicago PD. And in those 9 years, he'd compiled a record that should have ended his career long ago. 16 complaints, 12 specifically alleged racial profiling or excessive force against people of color. 6 sustained with written reprimands and mandatory retraining. 10 closed, does not sustain despite witness statements. The pattern was clear and documented. Carr saw black and brown people as inherently suspicious, inherently criminal, inherently threatening. 4 years earlier, Carr stopped a black teenager skateboarding in a park, detained him for an hour, searched his backpack without consent, found nothing. The teenager's father was a city alderman. Complaint filed, sustained. Carr received a written reprimand. 2 years ago, Carr responded to a noise complaint at an apartment complex. When he arrived, he found a group of black college students having a study session. He demanded IDs from everyone, ran warrants checks, threatened to arrest them for disturbing the peace, even though neighbors said the noise complaint was about a different unit. Students filed complaints not sustained. 6 months ago, Carr stopped an Asian American driver for a traffic violation. During the stop, he made comments about the driver's English and asked where he was really from. The driver was born in Chicago, spoke perfect English, and recorded the entire encounter. Complaint filed. Sustained. Carr received mandatory diversity training. But despite 16 complaints over 9 years, Carr remained on patrol because the system prioritized protecting officers over protecting communities. When Carr received the library call, his mind immediately constructed a narrative. Suspicious person at library, probably homeless, probably on drugs, probably trespassing. He arrived at 3:14 p.m., parking his patrol car at the main entrance. He walked into the library, took the elevator to the 9th floor, and found Patricia waiting. She pointed across the reading room. That's him, the one in the blazer at the table by the windows. Carr looked. He saw a black man sitting alone with books and a laptop. In Carr's biased mind, that confirmed the complaint. Black man public space obviously doesn't belong. Carr walked directly toward Elias's table. Elias was reading a Supreme Court decision about Fourth Amendment search and seizure when he became aware of someone standing next to his table. He looked up, a police officer, arms crossed, staring down at him. Can I help you? Officer, you need to leave. Excuse me, this is a public library. I'm studying multiple complaints about you loitering, making people uncomfortable. Elias blinked, confused. Loitering? I've been here 30 minutes reading legal case law. I'm an attorney preparing for a deposition. I have books checked out. I have my laptop. I'm not loitering. I don't care what you claim to be. You need to leave now. Elias felt his stomach tighten. He recognized what was happening. This wasn't about loitering or complaints. This was about a black man in a space where someone decided he didn't belong. Officer, I'm not leaving. I'm a library patron engaged in legitimate research. I'm not violating any policy. I'm not disturbing anyone. I have every right to be here. This is your last warning. Leave or you're being arrested. Elias made a decision. He could leave, avoid confrontation, let this violation go unchallenged, or he could assert his rights, document this injustice, and hold the system accountable. He chose assertion. Should libraries train staff to recognize racial bias before calling police? Let me know in the comments. Officer, what's your name and badge number? Carr, 3174. Officer Carr, I'm Elias Thorne. I'm a civil rights attorney. I've been sitting here quietly for 30 minutes reading case law for a deposition tomorrow. I'm not loitering. I'm not disturbing anyone. I'm exercising my right to use a public library. If you arrest me for this, you're violating my Fourth Amendment rights and I will file a federal lawsuit. Carr's jaw tightened. Are you threatening an officer? I'm not threatening. I'm informing you of the legal consequences of your actions. You're about to make a very expensive mistake. Several other library patrons had noticed the confrontation. Phones came out. People started recording. A woman at a nearby table spoke up. Officer, excuse me. I've been sitting here for 2 hours. That man hasn't done anything wrong. He's been reading quietly the whole time. This is inappropriate. Carr didn't even look at her. Ma'am, stay out of this. Another patron, a man in his 60s, stood up. I'm a retired attorney. I've been watching this entire interaction. This officer has no legal basis to remove this gentleman. This is harassment. Carr's hand moved to his handcuffs. Sir, I'm not going to ask again. Turn around. Hands behind your back. Elias closed his laptop slowly. He placed his legal pad on top. Then he stood, keeping his hands visible. I'm complying under protest, Elias said loudly, making sure his voice carried across the reading room. I am Elias Thorne, civil rights attorney. I've been sitting in this public library for 30 minutes reading case law. I violated no law, no policy, no regulation. This officer is arresting me for reading while black. Everyone here is witnessing this. Please record it. At least 5 people were recording now. The library's security cameras were capturing everything from multiple angles. Elias turned around and placed his hands behind his back. Carr grabbed his wrists roughly and snapped handcuffs on deliberately tight. The metal dug into Elias's skin. He winced but said nothing. You're under arrest for trespassing and obstruction. Trespassing in a public library. Obstruction by sitting quietly and reading. Officer Carr, you just arrested a civil rights attorney who specializes in suing police departments for exactly this kind of constitutional violation. I've won $13 million in settlements over my career. You're about to be my next case. Carr marched Elias toward the elevator. Other patrons were standing now, phones out, recording everything. The woman who had spoken up earlier called out, This is wrong. He didn't do anything. Someone else shouted, His name is Elias Thorne. He's an attorney. Look him up. Carr pushed Elias into the elevator. As the doors closed, Elias looked back at the reading room. He saw the phones recording. He saw the witnesses. He saw the evidence being documented. The case was already building itself. The elevator descended to the ground floor. Carr walked Elias through the main lobby. The circulation desk staff stared. Patrons turned to watch. A man in handcuffs being led out of a library for reading. Carr guided Elias outside to his patrol car. He opened the back door. Get in. Elias ducked into the back seat. Cramped space, plastic seats, plexiglass windows, smell of disinfectant. Carr got in front and picked up his radio. Dispatch Unit 14-1 in custody. Male black, approximately 40 years old. Arrested for trespassing at Harold Washington Library. Transporting to 1st Precinct. The dispatcher's voice came back. Copy Unit 14. What's the suspect's name? Carr glanced back. What's your name, Elias Thorne? Spell that last name. Thorne. The dispatcher paused. Unit 14. Can you describe the nature of the trespassing? Suspect was loitering in the library reading room. Library staff called it in. Multiple complaints. Unit 14. Did you verify with library management that the suspect was actually trespassing or violating library policy? Do you think officers should verify complaints before making arrests in public spaces? Drop your answer. Carr hesitated. Negative. Library staff reported it. That was sufficient. Unit 14, please stand by. Need to verify something. Carr sat there, engine idling. In the back seat, Elias sat perfectly still. He'd been in difficult situations before. He'd faced hostile judges, aggressive opposing counsel threatening defendants. But this was different. This was being treated like a criminal for reading in a library. The radio crackled. Unit 14, I'm showing an Elias Thorne as a licensed attorney in Illinois. Civil rights practice. Multiple high-profile cases. You need to verify this arrest is legitimate before proceeding. Dispatch the arrest is made. I responded to a complaint. I understand, but I'm advising you to return to the library and verify with management before transport. Confirm the suspect actually violated library policy. Carr's face went pale. He sat staring at the steering wheel. Then he got out of the car and walked back into the library. Elias watched through the window. He could see Carr talking to library staff at the circulation desk. He could see Patricia Vance, the librarian who'd called it in, gesturing animatedly. He could see Building Security Officer Wu shaking his head. 5 minutes passed. Carr came back out, walking slower, shoulders slumped. He opened Elias's door. "Sir, there's been a misunderstanding. I'm going to release you." A misunderstanding, Elias kept his voice level. "You arrested me for reading in a library. You handcuffed me in front of dozens of witnesses. You marched me out like a criminal, and now you're calling it a misunderstanding." Carr unlocked the handcuffs. Elias rubbed his wrists. Red marks circled them where the metal had pressed into skin. "Officer Carr, what you just did is called a Fourth Amendment violation. Arrest without probable cause, false imprisonment, deprivation of civil rights under color of law. And I'm a civil rights attorney who's built my entire career on cases exactly like this. Sir, I was responding to a complaint. Library staff reported suspicious activity. Suspicious activity I was reading. Let me be very clear about what happened here. A librarian saw a black man sitting quietly with books and decided I was suspicious. She called you. You responded and immediately assumed I was criminal. You didn't verify the complaint. You didn't check library policy. You didn't ask library management. You just saw a black man and arrested him. That's racial profiling, and I'm going to make sure everyone knows it." Elias pulled out his phone. He had recordings to collect, witnesses to contact, and a lawsuit to prepare. Carr tried one more time. "Sir, if you'd just cooperated and left when asked to leave a public library for reading, that's not a lawful order. That's discrimination, and cooperation with unlawful orders isn't required." Elias called his law partner. "Samuel, it's Elias. I was just arrested at the Harold Washington Library for reading while black. I need you to get down here immediately. Collect witness statements. Get copies of all security footage. Contact the library administration and prepare a federal civil rights complaint. We're suing Chicago PD and the city of Chicago." Within 20 minutes, Elias's law partner Samuel Sterling arrived with 2 associates. Within 30 minutes, they'd collected statements from 7 witnesses who'd recorded the incident. Within an hour, they'd secured copies of security footage from 4 different camera angles showing everything. Elias, sitting quietly reading Carr, approaching aggressively. The arrest without cause. The march through the library. Within 2 hours, the story was on local news. Civil rights attorney arrested at library for reading. The video footage was devastating. Elias Thorne, well-known civil rights attorney, sitting at a table with law books and a laptop being handcuffed and arrested while witnesses protested and recorded. The story went viral immediately. Within 3 hours, 300,000 views. Within 6 hours, over 2 million. Within 24 hours, 8 million people had watched a black attorney being arrested for reading in a library. The comment section exploded. If a Harvard law graduate and civil rights attorney can be arrested for reading "No black person is safe," this is exactly why we need police reform. That officer had no idea who he was messing with. Elias Thorne has won millions in civil rights cases. Chicago PD is about to pay. Local legal community responded immediately. The Illinois State Bar Association issued a statement condemning the arrest. The Chicago Bar Association called for an investigation. The ACLU announced they were monitoring the case. The NAACP Legal Defense Fund offered support. National civil rights organizations reached out. This wasn't just a wrongful arrest. This was a prominent civil rights attorney being profiled and arrested while doing his job. The symbolism was powerful and damning. Chicago Police Department issued a statement that evening. "We are aware of an incident involving one of our officers and a member of the legal community. The matter is under investigation by our Bureau of Internal Affairs. We take all allegations seriously." The statement was careful, neutral admission of nothing. It satisfied no one. By Wednesday morning, pressure was mounting. Chicago Mayor's office received hundreds of calls demanding accountability. City aldermen issued statements. Local media ran continuous coverage. Elias's law firm held a press conference. Elias stood at a podium with his partners beside him. "Yesterday, I was arrested at the Harold Washington Library for the crime of reading while black. I'm a civil rights attorney. I've spent 18 years fighting police misconduct and racial profiling. I've won landmark cases establishing constitutional protections. And despite all of that, despite my education, my credentials, my experience, I was still handcuffed and arrested for sitting quietly in a library with law books. He paused. This arrest wasn't about loitering or library policy. It was about a librarian who saw a black man and decided I was suspicious. It was about an officer who responded and immediately assumed I was criminal. It was about a system that allows officers with 16 complaints to remain on patrol. It was about institutional racism that criminalizes black people for existing in public spaces. Another pause. I'm filing a federal lawsuit. Not for revenge, not for money, for accountability, for reform for every black person who's been profiled, harassed, and arrested for living their lives. The press conference ended with Elias answering questions. When asked about damages, he said, "This isn't about a settlement. This is about changing a system." When asked about Officer Carr, he said, "Officer Carr is a symptom. The disease is a department that tolerates officers with patterns of racial bias. Should officers with 10-plus complaints be automatically removed from patrol? Comment below." Chicago PD Bureau of Internal Affairs launched an investigation immediately. Senior investigator Lieutenant Elena Rosa was assigned. Rosa was a 16-year veteran known for thorough investigations and unwillingness to tolerate misconduct. She pulled Officer Carr's complete personnel file. 9 years, 16 complaints, 12 alleging racial profiling or excessive force, 6 sustained. The pattern was undeniable. Rosa watched security footage from the library, 4 camera angles showing everything. Elias sitting quietly reading, taking notes. Carr approaching aggressively, hand near weapon. Elias explaining he was an attorney offering identification. Carr dismissing everything, making arrest witnesses, protesting phones recording. Rosa interviewed the witnesses. All 7 told the same story. Elias was sitting quietly reading. He wasn't disturbing anyone. The arrest was completely unjustified. Several witnesses specifically mentioned Elias explaining he was an attorney and offering credentials. Carr arrested him anyway. Rosa interviewed library staff. Building Security Officer Wu was direct. The librarian who called you racially profiled that gentleman. He wasn't doing anything wrong. I told her that. She called police anyway. I tried to stop this. Rosa interviewed Patricia Vance, the librarian who made the call. Vance was defensive. He looked suspicious. He didn't look like he belonged there. Rosa pressed. What specifically did he do that was suspicious? Vance couldn't articulate anything. He just had a look. What look? You know, like he was up to something. Rosa made a note. Racial profiling clear and documented. She pulled statistical data on Carr's stop searches and arrests over his 9-year career. Black residents stopped at rates 4.1 times higher than department average. Hispanic residents 3.3 times higher. Searches of black motorists 4.8 times higher. Use of force against people of color 3.7 times higher. Every statistical measure told the same story. Bradley Carr was an officer whose policing was driven entirely by racial bias. Rosa's investigation report was 52 pages. Officer Bradley Carr violated department policy, state law, and federal constitutional rights. He arrested Elias Thorne without probable cause. He failed to verify the complaint before making arrest. He ignored witness statements confirming Thorne's legitimate presence. He refused to verify Thorne's credentials despite repeated offers. He used unnecessary force with tight handcuffs. The arrest was motivated by racial bias. Carr observed a black man in a public space and immediately assumed criminal activity. He made no attempt to verify legitimacy despite Thorne's professional appearance, calm demeanor, and clear explanation. This pattern is consistent with Carr's career. Analysis shows 16 complaints, 12 alleging racial profiling. Statistical analysis shows Carr stops searches and uses force against people of color at rates dramatically higher than department averages. Officer Carr's continued employment poses direct threat to public safety and community trust. Recommended immediate termination. Chicago Police Superintendent Robert O'Malley read the report over a weekend, watched all videos, reviewed statistics. Monday morning, he made his decision. Officer Bradley Carr was fired. Termination letter was delivered by Lieutenant Rosa. 6 pages listing every violation. Conclusion clear. Officer Bradley Carr is terminated from Chicago Police Department effective immediately for violation of department policy. Further violation of constitutional rights. Unlawful arrest pattern of racially biased policing, spanning entire career. This decision is final and not subject to appeal. Carr's name was entered into the National Decertification Index. At 36, his law enforcement career was over. He hired attorney Simon Lee, who specialized in defending police officers. Lee reviewed the case, watched library security footage from 4 angles, read Elias Thorne's credentials, reviewed 16 complaint history, read statistical analysis showing clear racial bias, read Rose's 52-page report. Lee called Carr. Brad, I'm going to be honest. This is indefensible. You arrested a Harvard-educated civil rights attorney for reading in a library. It's on video from multiple angles. Witnesses recorded everything. Your personnel file shows 16 complaints with clear racial bias pattern. Department has ironclad termination case, and you arrested possibly the worst person you could have. Elias Thorne has won $13 million in civil rights settlements. He knows this area of law better than anyone. He's going to destroy you in court. What should happen to librarians who racially profile patrons? Let me know below. Lee's advice was clear. Withdraw appeal, stay quiet. Don't speak to media. Pray attention moves on. Carr withdrew, but Elias Thorne wasn't finished. The lawsuit was filed 8 weeks after the arrest. Elias's firm prepared a complaint that was 41 pages long. Fourth Amendment violation arrest without probable cause, false imprisonment, and false arrest. 14th Amendment violation, denial of equal protection, deprivation of civil rights under color of law. 42 U.S.C. Section 1983, intentional infliction of emotional distress, assault, and battery through use of handcuffs. Violation of Illinois Civil Rights Act. Municipal liability for failure to train officers on racial bias. Municipal liability for failure to supervise officers with documented patterns. Municipal liability for negligent retention of officer with 16 complaints over 9 years. Named Officer Bradley Carr individually and City of Chicago. Demanded compensatory damages, punitive damages. Policy reforms consent, decree with federal oversight city attorney's office, and insurance carrier brought in that outside counsel defense firm specializing in law enforcement cases. They spent 3 days reviewing everything. Videos from 4 library cameras, body camera footage, witness statements from 7 people with recordings, Elias Thorne's credentials and reputation, Officer Carr's 16 complaint history, statistical evidence of racial bias, Rose's 52-page investigation. Their conclusion was unanimous. This case is catastrophic. We have a Harvard Law civil rights attorney arrested for reading. Videos show everything. 7 witnesses with recordings. Officer has 16 complaints over 9 years with documented racial bias pattern. Plaintiff is one of the region's most respected civil rights lawyers who's won $13 million in similar cases. If this goes to trial, verdict could be 8 to 12 million times. City's insurance carrier agreed. Policy limit is $10 million. This goes to trial. We're looking at verdict that exceeds our coverage. Strongly recommend immediate settlement negotiations. City agreed. Settlement talks began 6 months after lawsuit filed. Elias's team opened with demand $7.5 million. Compensatory and punitive damages plus comprehensive reforms, including consent decree with federal monitoring. City countered $1.8 million. No admission of wrongdoing. No policy commitments. Elias's team didn't budge. They explained what trial would look like. We'll call every person Officer Carr stopped, searched, or arrested in 9 years. That's over 250 witnesses establishing pattern. We'll present statistical analysis showing his clear racial bias. We'll call expert witnesses on constitutional policing who will testify Carr violated every standard. We'll have Harvard law professors testify about Fourth Amendment. We'll make this a month-long trial with national media coverage. CNN, SNB, NPR in courtroom every day. And when jury returns verdict, it'll make national headlines because a Harvard Law civil rights attorney was arrested for reading. City raised offered $3.2 million. Elias's team held firm at $7.5 million. Negotiations stalled. Then Department of Justice Civil Rights Division announced they were opening pattern and practice investigation into Chicago PD. Investigation would examine whether department engaged in systemic racial discrimination. Changed everything. City couldn't fight federal lawsuit while under DOJ investigation. They needed this resolved. Final offer $3.8 million. Comprehensive policy reforms. Agreement to cooperate with DOJ investigation. Elias caucused with his partners. It wasn't the full amount they demanded, but it was substantial. And more importantly, reforms in DOJ cooperation would create lasting change. They accepted settlement announced at joint press conference. $3.8 million paid to Elias Thorne, one of the largest settlements for wrongful arrest in Illinois history, plus mandatory reforms. Annual mandatory training on racial bias for all officers conducted by independent experts. Early intervention system flagging any officer with 5 complaints in 3 years. Independent civilian oversight board with subpoena power and disciplinary authority. Officers must verify complaints with property managers before arrests on private or public property. All arrests must be reviewed by supervisor within 12 hours. Quarterly statistical analysis of stop searches, arrests by race and officer. Any officer showing disparities over 2.0 times department average triggers automatic investigation. Federal monitoring for 3 years. Annual public reporting of all complaints and discipline. Do you think $3.8 million is enough for being arrested for reading? Comment your thoughts. Elias issued statement. This settlement represents accountability, but money alone doesn't create change. What matters are the reforms, the oversight, the commitment to addressing systemic racism. I was arrested because a librarian racially profiled me, and an officer with 16 complaints assumed I was criminal. That can't happen again. Not to me, not to anyone. Reporter asked about the money. Elias answered, I'm donating $1.5 million to organizations providing legal aid to people of color who experience police misconduct. I'm using $1 million to establish a civil rights fellowship at Northwestern University Law School for students who want to pursue police accountability work. The remaining $1.3 million covers my legal fees and compensates me for the trauma of being handcuffed in front of colleagues and community for reading. DOJ investigation into Chicago. PPD took 18 months. Analyzed 60,000 stops over 8 years. Reviewed thousands of body cameras. Interviewed 250 officers and community members. Released 178-page report. Chicago Police Department engaged in pattern of conduct violating Fourth and 14th Amendments. Officers stopped people of color at rates significantly disproportionate to population. Black residents stopped 3.8 times higher rate. Hispanic residents 3.1 times higher. Asian residents 1.9 times higher. Disparities cannot be explained by crime rates, or legitimate factors constitute racial discrimination. Searches of people of color occur at dramatically higher rates despite lower contraband recovery. Use of force disproportionately deployed against people of color. Complaint system inadequate. Complaints from communities of color routinely dismissed. Officers with clear bias patterns not disciplined or removed. Supervision inadequate to identify and address problem officers. Chicago PD entered consent decree with DOJ. 104 pages. Legally binding. Federal oversight. 5 years. Any officer with 8 sustained complaints must be removed from patrol pending review. Any officer with 5 complaints in 2 years triggers mandatory intervention. All stops must be based on reasonable suspicion or probable cause clearly articulated. All searches must be based on probable cause or valid consent. Body cameras mandatory for all uniformed officers. Footage reviewed regularly. Enhanced training 60 hours annually on constitutional policing. De-escalation implicit bias. Independent civilian oversight board with full investigative and disciplinary authority. Quarterly statistical analysis with public reporting. Federal monitor with complete access and authority to report noncompliance. Chicago City Council held hearing on consent decree. Elias testified, "What happened to me was not unique. It was documented. Thousands of people of color in Chicago experience profiling, harassment, unlawful stops every year. Most don't have Harvard law degrees. Most don't have resources to sue. Most suffer in silence. That's why this consent decree matters. It's not punishment, it's accountability. It's a blueprint for constitutional policing. It's protection for communities that have been targeted for too long." Consent decree approved unanimously. Chicago library case became national training example. DOJ uses library footage and civil rights training. Police academies show video as example of what not to do. Law schools teach case and constitutional law. One wrongful arrest at a library led to fired officer $3.8 million settlement comprehensive reforms. Federal consent decree. Bradley Carr never worked law enforcement again. Decertification index made him unemployable. Tried private security. Fired when employer learned his history. Tried retail loss prevention. Quit after being recognized by customers. Moved to different state. Works construction under different name. Gave one interview before leaving Chicago. Reporter asked by, Do you believe you were wrong to arrest Elias Thorne? Carr answered, I was responding to a complaint following procedures. Reporter pressed, you arrested an attorney for reading on video from 4 angles with 7 witnesses saying he did nothing wrong after he explained who he was. How is that following procedure? Carr stood and left without answering. Elias Thorne continued his civil rights practice. The arrest didn't slow him down. If anything, it strengthened his resolve. He's filed 6 more police misconduct cases since winning 4 so far. Total settlements now exceed $18 million. He speaks at conferences about his experience. Shows the library video explains how even credentials, education, professional status don't protect you from racial profiling, but also how documentation, witnesses, and legal knowledge create accountability. He teaches his law students record everything. Know your rights. Never accept injustice as inevitable. Challenge it. Document it. Fight it. The library security footage is still available. You can watch it yourself. Elias Thorne, Harvard Law, graduate, former federal prosecutor, civil rights attorney, sitting quietly at a table with law books and laptop being arrested for reading. You can see Officer Carr approach aggressively. You can see Elias explain calmly who he is. You can see Carr dismiss everything and make arrest. Anyway, you can see witnesses protesting and recording. You can see evidence of racial profiling playing out in real time. What's your biggest takeaway from this story? Drop it in the comments. Elias's story matters because it proves that racism targets everyone regardless of education or status. Harvard Law degree, 18 years, legal experience, $13 million in 1 cases. None of it protected him from being arrested for reading while black. Think about everyone without those credentials. Everyone who gets profiled, stopped, arrested without witnesses or recordings or legal knowledge to fight back. Everyone whose story doesn't make news because they're not prominent attorneys. Elias's story also proves accountability is possible. Officer with 16 complaints finally fired. City paid $3.8 million. DOJ forced comprehensive reforms. System changed, not because it wanted to, but because Elias refused to accept injustice. If this opened your eyes to how racial profiling operates in everyday spaces, subscribe. We're bringing stories that challenge, inform, demand accountability. Share with someone who needs to understand what racial bias looks like. Not theories or statistics, but concrete reality captured on library cameras. Hit subscribe. Drop comment. What reforms matter most? How do we prevent the next Officer Carr? How do we protect people just trying to read work? Live their lives in public spaces? These questions matter because this isn't just Chicago, or Carr, or Elias. It's about every community where black and brown people are criminalized for existing. It's about whether we accept systems that protect racist officers, or demand systems that protect the people they're supposed to serve. Thanks for watching this story. If it changed how you think about racial profiling and police accountability, you've learned something important today. Now take it further. Share it. Discuss it. Demand better from your community institutions. Change happens when we refuse accepting anything less than justice.